The following reenactment is taken from an actual case. The deposition dialogue is taken directly from the public record. Everything else is commentary.
I hate having to go to the judge. But this guy, I've never seen anything like it. I really didn't want to have to go to the judge, but...
Take whatever action you want to take. I mean, he's trying to answer your questions. He is answering your questions, and he'll continue to answer your questions.
I'm going to ask the question again, and I'm going to ask it in a different way so as to make sure I'm not characterizing the witness's testimony.
Get his permission.
I don't need his permission.
Yes, you do.
My question is, in submitting loans originated by HMFC for purchase by GMAP, was it HMFC's policy that so long as there was an appraisal that supported the value of the property, it was not up to HMFC to report to GMAP flip activity?
Same objection, go ahead.
My attorney just told you to get fucked, and so do I.
No.
First of all,
Okay, that's for the record.
no, your attorney did not tell me that. You told me that. And now you can answer my question.
Get fucked.
You're not going to answer the question.
I just did answer the question.
No, that's not an answer to the question.
That is my answer to your question.
Okay.
My attorney very nicely said that he objects. Fuck you. So I am telling you on behalf of my attorney, fuck you.
File whatever motion you want to file.
Oh, judges hate it when you waste their time. I mean, they hate it.
But yeah, sometimes lawyers will come to the judge and say, look, I think I'm going to have a problem with this, or in the midst of the examination when the problems are occurring, they'll come and ask the judge to do something.
I think the first thing that I thought of was that he must have been terrified of that judge. He did not want to go in front of that judge. That, of course, I don't know this for sure, but that was my, and I've dealt with lawyers who are really afraid of certain judges. And I know it may not be any judge, but particular judges can inflict the fear of God in people. And I've seen that firsthand. And so my sense from my experience in the courtroom was, for whatever reason, he was terrified of getting in front of that judge. Maybe he didn't have a lot of actual courtroom experience. Maybe he's just used to deposing people. I mean, but he was, you have to have a serious desire to avoid laying eyes on that judge to stay in that for 12 hours, especially over the course of 2 separate sessions where you have had to have had some time to regroup and talk to yourself. Okay, the last time I had this guy in here, he was this, he did this. Every time I asked these questions, this was the response. How am I going to shift my tactics here to make this worth anybody's time? Why would I try again? First of all, why try again? And second of all, what am I going to do differently to try to make some progress here? And it was very clear that absolutely no, it didn't appear that any tactics had changed at all. He threw himself back in the lion's den and just got beat up by the guy again. And so my sense is he was terrified, maybe terrified to go in front of the judge. Maybe he's just a super passive guy. Maybe he just gets stunned and doesn't know how to react when somebody is aggressive. I mean, I have no idea. It could be a million things because I don't personally know him, but it's the one thing that I did think of was that judge fear.
When lawyers don't control their client, or don't control their witnesses, or the witness they're questioning in court, in a couple of ways. Sometimes they don't have the witness speak loudly enough so everyone can hear it. It's very common for lawyers to talk over witnesses and more common for witnesses to talk over lawyers. That is, start answering the question before the question is finished. That's bad because it's hard for the jury and the judge to understand it. The court reporter can't get it down. So quite often I will say to lawyers, either at the bench or at least in a non-jury trial, I'll say, you know, you have to control this witness, be sure the witness speaks up, be sure the witness doesn't talk until you're done, and so forth.
It varies from lawyer to lawyer, and it varies from area of law to area of law. Like, family law, you can forget it, because everybody wants to go out and hire the nastiest, rottenest lawyer they can find. When you get into a probate practice, everybody wants to be kind of quiet and respectful.
I mean, there are consequences to this. Is everything going to be in front of this judge? Okay, the one who has to deal with this guy screaming, saying the Effenheimer every 3 seconds? What are the repercussions? What are the repercussions of letting him run like this? And getting the lawyers on the other side so entrenched in their dislike for this guy that they're going to stop at nothing to punish him for embarrassing them in that way. So those are the kind of repercussions that I see. But in addition, he could have helped himself potentially and clarified some issues and taken the heat out of some of the suspicions of the people who were deposing him. You have to assume that every single suspicion may or may not be true. And the things they're questioning about, while true, a fishing expedition, he could have dismissed some of the things and made the case a little bit easier to manage on his end. But he had no opportunity to do any of that because he couldn't shut up and nobody stopped him, and his lawyer didn't say, "You're not helping yourself here. You're hurting yourself on many levels. This is not good for your case. So suck it up and answer the questions, or we're going to end this and we're going to have to deal with the judge." And I don't think you want to do that.
It comes down to the issue of client control. And if I can't control a client, I'm not going to represent the client.
I think if a lawyer pulled rank, a lawyer who had previously aligned with him, he believed his lawyer was a decent lawyer. He's the greatest, smartest legal mind of all time. So he would only pick the greatest, smartest lawyer of all time, who was probably not as expensive as others. And so he could have potentially made some ground with that. He could have. If he couldn't, then what was he doing in there in the first place?